A motion in limine is a legal request made before trial to exclude or limit certain evidence or arguments during a trial. The phrase in limine means at the threshold, and it's a way for attorneys to address potential evidentiary issues before they arise at trial. April 9th, 2025. Motion number 4, conditions as an aggravator. Using Bryans autism spectrum disorder or ASD diagnosis as an aggravator at the penalty phase of the trial, if there is one.
All right, let's talk about the defendant's motion regarding conditions as an aggravator, and this is the concern about using the defendant's alleged autism disorder diagnosis as an aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for a trifurcation with the death penalty, and that was denied. But we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Bryan, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Bryan's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Bryan is. We seek to prevent the state from using those kind of characteristics against Bryan. We seek that in the way of testimony they might bring. Sometimes Bryan will talk longer than maybe other people want to listen, and that doesn't mean anything.
Well, I assume he's not going to be talking in court unless he's testifying, so.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating evidence against Mr. Kohberger, and that's what we don't want. We want to be able to present, if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has and to prevent the state.
Reading the the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do with, how we deal with that with the jury in terms of the penalty phase, right? If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
How would they use it as aggravating apart from arguing to the jury that, well, you know, because he has this condition, it means that he is, I'm just making this up, obviously, is inclined to not follow the norms of society and presents a greater danger or something like that?
Your Honor, the order would prevent the state from, on the front end, in presenting their aggravation case, from using the conditions, the way autism works for Bryan, against him, to say that he does things that are consistent with autism and that that's an aggravating circumstance.
I'm just having a hard time envisioning what that would be, how it would be presented in a way that is making it an aggravator.
Well, I would hope that it wouldn't be presented that way. But, Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Kohberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him. And a lot of their unkind things, when you understand them in the context of autism, the way he may stand in a room near a doorway, the way he may look too long at a person, their interviews are different when you know he has autism and you know the characteristics he displays. But those awful comments, those mean comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I, though, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to in a mitigation aggravation penalty phase. Your position is that's due to his spectrum disorder, whereas the state's view may, no, that's not. That's his view of women and goes to motive, et cetera, and goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem, Your Honor. If the state, and
Do you want me to,
I want
you want
be
me to weigh in and
clear.
say what the factual findings are, that it's this and not that? And I'm not sure I can do that as short from a jury instruction that, you know, you cannot use mental health conditions as an aggravating factor.
That's an appropriate jury instruction, and if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present mitigation.
There may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that the court will not find that that comes up. I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with and that Mr. Kohberger's constitutional rights are protected.
Thank you.
Now, this would be the state's response of the conditions as an aggravator using Bryans ASD at the penalty phase of the trial. They claim they're not going to.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to, if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation. Thank you, Your Honor.
Now, this would be the defense's rebuttal about using Bryans' autism spectrum disorder as an aggravator at the penalty phase of the trial to what the state just said.
Response?
We understand that the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryans' autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
Thank you. Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. The state certainly shouldn't make those arguments and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. And so I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say don't make that argument that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the symptomology that the defense contends is part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor.